Welcome. I know everybody's just getting connected. Thank you so much for coming today. I really appreciate it. Good afternoon. Thanks so much. I am happy to see you here. Happy to present another monthly webinar. As you know, I'm Shanna Welsh-Levin. As everybody's getting logged in here, I'll go over a few housekeeping rules. As you know, we are recording the webinar. That is what we always do. And in order to protect your privacy, when we edit the video, they will take out the names and any faces if you don't have your camera turned off, or if you choose to turn your camera on, your name and face won't be seen on the video. We do post the videos on YouTube, and we also send out the video to everyone who signed up, even if they did not attend. We send freebies also with the video. So there's a couple of really good freebies that we'll give to you today. The information I'm giving you today is not to be considered legal advice. So please refrain from using the information as legal advice applicable to any particular set of circumstances that you might have. If you do have specific questions about something that you're going through and you want an attorney to review it, we offer free 15-minute consultations for any new potential matter, and we'd be happy to talk to you and answer the specific questions after the webinar. But you're welcome to post your questions in the chat. General questions, I will be happy to save time at the end and answer those questions. And if we don't have enough time at the end, I will download all the questions and write out the responses and send those out with the video as well. So please feel free to put your questions in the chat. They'll only be visible to the host and the co-hosts. So you don't have to share your question with everybody. Just post it to me or to the host and co-hosts. Our amazing team is growing quickly. We've got 2 additional attorneys who are helping me out. We're getting busier and busier, but we also have a lot more potential to handle the volume of cases that we're getting. So we have Adam Stone, who is our transactional real estate attorney, and he is handling primarily transactional work. He also does some litigation. And then we have Jim Delaney. So if anybody's working with us on a litigation case or an unlawful detainer, you've met Jim Delaney. And then many of you have met Lisa Manriquez, our wonderful unlawful detainer and transactional real estate paralegal, and also our litigation paralegal, Fabian Garcia Brown. So I hope that you've had a chance to meet some of our team members, or you've been staying out of trouble and you haven't needed us. Either way, great. And if this is your first webinar, please enjoy. So as you know, or as I hope you already know, I'm Shanna Welsh-Levin with SoCal Realty Law. And at SoCal Realty Law, we protect real estate investors and real estate professionals. We have been presenting these monthly webinars since April 2020. We like to show up every month, and I in particular show up every month to try to present to you some current information that I think would be helpful. Oftentimes I choose the information based on what we're getting the most questions about. So lately we've been getting a lot of questions about cash for keys, relocation assistance, buyouts, lease buyouts, and then tons of questions about California's ballot proposal number 33. So as new legislation passes, we do want to do more webinars to present to you the new legislation, but today I'm going to limit it because the discussion of cash for keys, relocation assistance, and lease buyouts can take some time. There's a lot of interesting variation, and I hope that you guys enjoy this and feel a little bit better informed once the webinar is completed. All right, so when I talk about quote unquote cash for keys, the cash for keys is that old school, practical, common sense type of agreement where, you know, the landlord just needs to pay the tenant or wants to pay the tenant to move out. Landlords started using cash for keys long before I ever started practicing law. It's a really common sense idea. If you have a tenant, as a landlord, if you have a tenant that you need to get out of the property and you want to avoid going to court or getting into a dispute, and you want to make sure that the tenant leaves the property in good condition without doing any damage when they go, then you can offer the tenant an amount of money in exchange for their written agreement to move out. And I stress that it needs to be a written agreement. However, even if you can't get the tenant to sign a written agreement, you can still do a cash for keys verbal agreement. The difference between having it in writing and having just a verbal agreement is that if it's not in writing, then you can't enforce it in court. But a written cash for keys agreement fulfills the requirement of just cause. So if the tenant signs it and agrees to a move out date and then doesn't move out as agreed, instead of having to issue a new notice to terminate their tenancy, the written cash for keys agreement can be used in lieu of any other notice. So if that date comes and they decide they're not going to move out, then you can just proceed to court and attach the written cash for keys agreement to your lawsuit instead of a notice. And that fulfills the requirements of just cause under Civil Code Section 1946.2. So those written agreements should include a mutual agreed upon move out date, an amount of money that will be exchanged, and also state what will happen, such as when the money will be paid and under what conditions it will be paid. So if the written agreement has all of those essential elements, it becomes enforceable, and then it may shortcut the problem if the tenant chooses to violate the agreement. But I would also say that it's more common than not that when the tenant agrees to the incentive, to the cash for keys, that they do move out. It's very effective because I think there's a mindset that if they've signed an agreement that they're going to follow through. The term cash for keys itself is really, when I use it, I mean that it's just an incentive that's paid in exchange for the move out agreement. It's not required by law. If it's required by law, then I'm calling it relocation assistance. And that's in my opinion, the definition or the difference between cash for keys and relocation assistance. So for cash for keys, keep in mind that there are many local jurisdictions that, such as the city of San Diego, that have adopted restrictions and requirements for cash for keys agreements. So first of all, we'll talk about the basic terms that need to be included in any written cash for keys agreement, just in order for it to be enforceable. We're not talking right now about what is required for a local ordinance to fulfill the requirements of a local ordinance. So just your basic agreement has to have certain things to become a contract and be enforceable under the law. Later in the webinar, we'll talk about the specific provisions required by the city of San Diego and elsewhere for those, what's called in the city of San Diego buyout agreement. So the essential elements for the cash for keys agreements, you have to have a mutual agreement to terminate a rental agreement. So you can't change the terms of the tenancy or require a tenant to move out unilaterally, meaning just the landlord wants them to move out. You can't force them to move out that way. But if you have a mutual signed agreement, then that effectively terminates the rental agreement. The agreement has to have the date and the time of the agreed upon move out, the date and time when possession will be returned to the landlord, the amount of cash that the landlord will pay in exchange for those keys, in exchange for that turnover of possession. The agreement should include, it is important for the agreement to include that the tenant will leave the premises in good condition. And we say clean and sanitary condition. Other terms that we use are quote unquote broom clean condition, which is kind of a term of art, meaning, it's not trashed. It doesn't have to be professionally cleaned in order to receive the cash for keys, but at least they have to take all their personal belongings away, leave it without any garbage laying around, clean out the refrigerator, stuff like that. And then it's up to the landlord if you want to hold them to a higher standard or not. I usually recommend keeping the standards pretty low because getting them out is a pretty good benefit. If you don't have to file an eviction, that's usually a really good thing. And the value of that far exceeds the cost of having the premises professionally cleaned. The agreement should also state that the tenant relinquishes their rights to any personal property left on the premises. Another way to say it is that anything left behind is considered abandoned and may be disposed of by the landlord. And this avoids the requirements of providing them with a notice of their right to come and collect their things. Which, if it's not in your agreement that they agree to abandon those personal possessions, then you have this statutory requirement where you have to give them notice of their right to reclaim their personal property, and then you have to store the personal property for a certain amount of time. And finally, I like to include, and I think it's important to include, a contingency that the landlord and the tenant will meet on the move-out date and walk the property prior to paying the cash incentive in order for the landlord to confirm that the premises are in good condition. This confrontation is something that many landlords use an agent to do. So they will have like a real estate professional or a friend who maybe has a little more courage to go and do the meeting with the tenant. There is a potential for confrontation when you do the walkthrough with the tenant, because if the tenant has not complied with the agreement, the landlord or the agent is in the position of saying, I'm sorry, I'm not giving you the relocation assistance. And then what do you do? That puts everybody in a difficult position. One more recommendation that I didn't write down here, but I often use, is just having the tenant sign or write down a statement that on such and such date, the tenant vacated the premises, and then have them sign it and write the date. That can avoid any disputes or he said, she said kind of situation that might arise if later on the tenant said, oh, I didn't mean to vacate, I want to move back in. But once the landlord has possession, then it's okay to change the locks. The written agreement supports that. And the idea is to make sure that we've documented enough to protect the landlord from any claims of wrongful eviction by the tenant. So at that point, once you've done that walkthrough, you've got your written agreement, the first written agreement. If you can get the second thing where they write down that they agreed to vacate, great, but the first written agreement should be enough. The act of turning over the keys is helpful, and then exchanging the cash. And all of those things result in possession of the premises going to the landlord. So we have a freebie that we'll provide with the video that has your basic cash for keys agreement. So the next question is, what amount of cash is usually enough? How do we calculate the amount of cash that should be paid under the cash for keys agreement? When relocation assistance is required by law, we'll talk about that in a couple more slides. When it's required by law, then the amount of relocation assistance should be at least the amount that the law requires. But if there is no required amount by law, then the usual answer I give to this question is, how much do you think it would cost them to move? Like if you had to hire a mover. And then based on fair market value of the property that they're in, how much would their first month of rent and security deposit be? So basically 2 months of rent for the property that they're in, because we're assuming they're moving to a similar property, similar size. So depending on how many rooms the property has and how much a moving company might charge for the move, plus your 2 months of fair market rent for a similar property. All right, and then should a landlord use an attorney to draft a cash for keys agreement? I have drafted tons of cash for keys agreements in the almost 20 years that I've been practicing. And I do highly recommend that a landlord use an attorney to both negotiate and draft cash for keys agreements, because there can be some pitfalls. It's certainly not required, and a lot of property managers have tons of experience doing this and are perfectly competent to do this. And many landlords also have lots of experience doing this. But if you do use an attorney, here are a few provisions that an attorney would generally add. So I call these a surrender and release agreement. So the release part of this is, do you want to have the tenant release the landlord from any liability, any known or unknown potential liabilities, lawsuits? And does the landlord want to release the tenant from liability? So the standard surrender and release agreement that we use has only a signature line for the tenant, but you can add the signature line for the landlord. You can call a release agreement either mutual or not mutual. I mean, it either says that it's mutual or it doesn't say mutual. And so you can choose how you want to carve out a release agreement with the tenant. There's a statutory civil code section 1542, which provides that a release does not apply to any unknown claims at the time that the release agreement is signed. So attorneys will include a section 1542 waiver. We waive civil code section 1542 so that the release agreement applies to all known and unknown claims up to the date that that release agreement is signed. We like to include statutory references to civil code section 1841.2.
It's recording though.
Okay, sorry, if you have some questions, I will pause after we go through these slides, and we can answer questions just about the cash for keys and relocation assistance before we move on to Prop 33. All right, so references that attorneys will also include in a surrender and release agreement include 1941.2. That's where the that is the statutory reference to the premises being clean and sanitary. So we say that the premises will be delivered to the landlord pursuant to section 1941.2 in clean and sanitary condition, free of personal belongings, garbage, and other waste. Also, we reference 1950.5, which is the security deposit statute, and that provides for the 21 days that the landlord has to assess the condition of the property and return the deposit. Section 1950.5 also discusses the tenant's notice of right to final walkthrough. So if you are entering into the surrender agreement a couple of weeks prior to the actual agreed upon move out date, I recommend including this notice of right to, it's actually right to pre-move out inspection in that agreement, just in case your lease doesn't have it. It's good to start throwing in this notice of right to pre-move out inspection whenever you're doing an agreement with the tenant, just in case your lease is missing it. The standard California Association of Realtors form has it already in there, and I recommend leases should have it in there, but in case they don't, you can throw it in whenever you need to. You can also issue the notice of right to final walkthrough or pre-move out inspection 2 weeks prior to the termination of the tenancy, and it's required by law to be provided at least 2 weeks prior to termination of the tenancy. And then it's up to the tenant to ask for the walkthrough. If the tenant doesn't ask for the walkthrough, then you don't have to conduct one. All right. So then let's talk about relocation assistance. So there are a lot of laws that require relocation assistance. The big difference between what we were talking about, cash for keys, and now relocation assistance is that relocation assistance, when I use the term, refers to tenant protection laws that use this term. And it is mandatory pursuant to those laws when a tenancy is being terminated by a landlord and the tenant is not at fault. So a no-fault termination of tenancy under many circumstances, under most circumstances, does require relocation assistance to be paid to the tenant. There are a lot of exemptions, properties that are exempt from the California Tenant Protection Act and other local ordinances. So in California, let me just go into that for a little bit. In California, many properties are subject to mandatory relocation assistance. And we don't really have time to go through that whole analysis of whether a property is exempt or not exempt. Most single-family residences may be exempt from the California Tenant Protection Act and local ordinances, but you have to go through an analysis of where the property is located, how many units are on the property, whether the premises are owner occupied, and whether the eligible landlord has claimed the exemption. So even though you may be exempt from tenant protection laws, most of them require you to give the tenant notice before you can be exempt. So you have to give the tenant the notice of exemption in order to claim the exemption. So for properties that are not exempt, these landlords who are not exempt need to include, if you're giving a 30 or 60-day notice to terminate the tenancy and it's not the tenant's fault for termination, then the landlord has to provide the amount of relocation assistance in the notice. It's very important to include it in the notice because California law requires it. And even though there may be a local ordinance that that is superior to the statewide, or that is more protective than the statewide law, it's still important to include the amount of relocation assistance in the notice. So as I mentioned, the relocation assistance is required if the termination for tenancy is not the tenant's fault. All right, let's talk about California Tenant Protection Act. So the California Tenant Protection Act is as far as the local ordinances that I know of, the Tenant Protection Act is the least restrictive law, which means that most of the local ordinances are going to supersede this law. They're going to apply instead of the California Tenant Protection Act. That's because the Tenant Protection Act only requires the landlord to pay 1 month of rent as relocation assistance. If the tenant is not paying any rent, then we default to fair market rental value. You could arguably put 0 relocation assistance because 0 rent is being paid by the tenant. You can test that theory out in court. I don't like being in that position of wondering whether a judge is going to say, well, if they don't pay any rent, then you have to use fair market rent. So I usually recommend fair market rent. And if the landlord doesn't want to include that in their notice because they feel that it's unfair that the tenant hasn't been paying rent. I completely understand, and we can move forward with the notice, but with that caveat that it may be defective. Other cities that have relocation assistance laws, and this on this slide is not a complete list, nor is the list that I'll read to you. There are many, many, many cities in the state of California that have local relocation assistance laws. The city of San Diego requires either 2 months of rent or 3 months of rent. It's 3 months of rent if the tenant is elderly or disabled. Now, how does the landlord know that the tenant is elderly or disabled? If you have asked any questions in the application about whether a reasonable accommodation is required, you can't ask specifically, are you disabled or what disability do you have? But if there's any reason why the landlord should know that the tenant is elderly or disabled, then it is important to acknowledge that and offer 3 months of relocation assistance. The city of San Diego has special restrictions for buyout agreements. So the city's ordinance calls them buyout agreements. If the landlord is engaging in a cash for keys agreement and the landlord is not exempt from the city of San Diego ordinance, then there is a specific buyout disclosure with language that must be provided to the tenant and signed by the tenant. The writing must be in 14-point font. It's extremely specific. You have to provide this disclosure to the tenant about their rights prior to engaging in any discussion of a buyout agreement. And then the city requires specific language in the buyout agreement. So I'll provide you with those forms as a freebie with the webinar as well. And then under this law, the relocation assistance under the city of San Diego, relocation assistance must be paid within 15 days of entering into the agreement or giving the notice of termination of tenancy. Then we have the city of Los Angeles. So if you are familiar with the county of Los Angeles, there are lots of cities in there in that county, and many of them have their own local ordinance. So we're talking about the city of Los Angeles rent stabilization ordinance requires significant relocation assistance that varies depending on how many years the tenant has been living there, how many other rental properties the landlord owns, among other factors. So the minimum relocation assistance in the city of Los Angeles is $9,900, and that's a discounted rate for mom and pop landlords, which means landlords who own a certain number of properties. That amount is paid per unit, not per tenant. The higher end of relocation assistance in the city of Los Angeles is over $25,000. That also must be paid within 15 days of entering into the agreement or serving notice of termination of tenancy. And then in LA and other cities, the landlord who intends to pay relocation assistance to the tenant has to file an application and then pay an administrative fee to the city in order to apply to pay the relocation assistance. Similar provisions exist in the city of West Hollywood, the city of San Francisco, the city of Burbank, city of Mountain View, city of Modesto, city of Oakland, and city of San Rafael. And there are many, many more. All right. So once again, the city of San Diego Tenant Protection Ordinance has gone into effect in 2023. And as I mentioned, that some cities have an application that you have to do in order to provide relocation assistance. We do not have one yet here in the city of San Diego. We don't have an administrative application because the registry that our ordinance calls for is being developed by the San Diego Housing Commission, and it's not ready yet. It's still waiting for further action from the city council relating to their trust ordinance, transparent and responsible use of surveillance technology ordinance. And again, in the city of San Diego, there's this buyout disclosure and buyout agreement that's called for under the statute, but the use of the term buyout agreement to me was confusing. And I've had this discussion with many people. So I wanted to talk a little bit about what is a real lease buyout agreement, the way that I've used the term for the many years that I've been practicing law. Prior to the city choosing this term, when I talked about a buyout agreement, it was this kind of common sense way of using it. If a tenant has an unexpired term lease, so for instance, they have a 1-year lease, they get to the 5th month of the lease, and the landlord suddenly realizes that they need to try to get the tenant out. So the landlord is trying to literally buy out the last several months of the lease. They're purchasing the remainder of the lease from the tenant. And that, in my opinion, is a real buyout agreement. So the factors to consider and the amount that's paid for that buyout, there are different factors, although they are similar to the cash for keys. So whether the contract is a good deal. If the lease is below fair market value, then the tenant has some leverage to ask for more money than just it's not a random amount. The tenant would provide a fair market value, or look at other rental listings that where they would have to go to and say, well, hey, landlord, if you buy me out of this, I'm going to have to pay an extra $500 a month. So that should be included for the next 7 months. And that would be, that $3,500 in addition to the moving expenses. If it's a very large house, then moving expenses would be more. The inconvenience. So if you're in an area where there aren't a lot of properties available for rent, or this tenant has looked and can't find another convenient place for them to move to, then there might be a premium charged by the tenant or asked for by the tenant. The number of people who are moving, there might be a factor if they are not all moving to the same place. If they're not a family that's all going to move together to a new place, but instead 2 tenants that are not going to live together anymore, then they might try to negotiate separate buyout agreements. And then residential versus commercial have different factors. So I just wanted to mention that these factors are for residential property. If you're talking about a buyout agreement for commercial property, they tend to be a lot more expensive. There are factors such as marketing and the administrative cost of changing an address, various things that businesses kind of develop over time from staying in the same place. Okay, so I can pause here for a minute and look to see if there are any particular questions in the chat. It doesn't look like we have too much in the chat. Does anybody want to take a moment to talk or answer any questions about relocation assistance, cash for keys, and lease buyouts? You could unmute, or you can post. There is a question here. Am I going to post the slides in a PDF? Yes, I will put the slides into a PDF, and when you get the video from today's webinar, you'll also get the PDF of the slides and the couple of freebies that I talked about, the short move out agreement and then the City of San Diego buyout agreement. Okay, then we'll just move on to, oh wait, hold on. I think I've got one more. Are these all applicable or needed if a landlord intends to sell the property? Yes. So if the landlord intends to sell the property or go out of business, that is a no fault just cause basis for terminating the tenancy. So for a non-exempt landlord, that landlord would have to pay the applicable relocation assistance, and it needs to be stated in the notice of termination of tenancy. Another way to go about it would be to enter into a buyout agreement, not a buyout agreement, but sorry, to enter into a written agreement for relocation assistance, a surrender and release agreement. That would make more sense because you can put into that agreement more of the terms that are advantageous to the landlord, like the 1941.2 condition of premises terminology, the security deposit terminology, the notice of right to final walkthrough. All of these things, as well as the release agreement, can protect the landlord, and you can pay the same amount of relocation assistance. You agree on the mutual surrender date, and you can still use that agreement in lieu of a notice. So if you can do it, I recommend doing the agreement instead of the 30 or 60-day notice. So if the lease is coming to term, next question, if the lease is coming to term, is it necessary to pay the buyout? Yeah, in California, just because the lease term ends, that is not a just cause to terminate the tenancy. California law states that if a lease term ends, the lease automatically becomes a month-to-month lease. And then if the landlord accepts rent for the next month, they have now accepted a month-to-month lease. If you intend to remove the tenant when the lease term comes to an end, then if you're not exempt, you have to give the 30 or 60-day notice with the relocation assistance. And by the way, the term of under the California Tenant Protection Act, 1946.2, the no fault just cause for evicting the tenant, actually it is an at fault just cause for evicting the tenant when the lease comes to an end. You would have to offer them a new lease with similar terms, and then the tenant has to reject that lease. So you have to give them a written proposed lease, similar terms. The tenant has to say, no, I'm not signing that. And you can use that for an at fault just cause. If it is an at fault just cause, then you don't have to pay relocation assistance. So I can dig into that issue a little bit more at the end if that's confusing. I'm not sure that I explained it very well. If the lease is coming to term, is it necessary to pay the buyout? That was the same question. Oh, no, sorry, that is the same question. Does the same apply if a family is moving back into the unit? Yeah, so there are incidences where the family is paid to move out. If the agreement includes the release, other language that may be included is that, they release any right to come back to the property. Now, when you terminate the tenancy for a no fault just cause, like you're going to do a substantial remodel or substantial construction, in the city of San Diego, you have to give them notice of their right to come back to the premises if the premises go back on the market within 5 years. And so there's a whole procedure written into the statute for that. But yes, anytime you send a 30 or 60-day notice to terminate the tenancy for a no fault just cause reason, you have to offer the relocation assistance in the notice. If you're in escrow to close in 6 months, can you raise the rent in the interim? Perhaps they leave on their own. Increasing the rent is something that we look at on a case-by-case basis. So I can't really answer that question because I don't know the other things that I would need to know. But you can raise the rent if under the law you are allowed to raise the rent under the circumstances. It doesn't matter whether you're in escrow. Escrow doesn't change the factors. What about if the property is for sale and the tenants are not performing and the tenants are not allowing entry for inspections or contractors to come into the property? Can we call the police on that tenant. Well, I mean, if the tenants aren't letting people in and they're not performing, I'm not sure exactly what that means, but for instance, if they're not paying rent, you can terminate the tenancy with a 3-day notice to cure the breach or quit. So if the tenants are in breach, then you can demand that they cure the breach or they move out, and then you can start an eviction. Calling the police on a tenant, if the tenant is committing violence, then yes, absolutely. Call the police if they are committing a crime, committing violence. Calling the police because the tenant is not letting your contractors into the property or inspectors into the property is not going to be effective. The police will tell you, I'm sorry, it's a civil matter. You're going to have to talk to an attorney about that. Does Encinitas have relocation assistance? Not that I know of. These things are constantly changing, but I have looked at Encinitas's website in the last year. Last time I checked, they did not have a relocation assistance ordinance. Got a lot of questions here. I am going to save some time for Prop 33, but let's do these questions first. Within 5 years, do you have to offer the unit back at the same rent, or can you re-rent at a higher rate after the remodel? You can. It's the City of San Diego ordinance is silent on that issue. I was just looking at this yesterday to answer the same question for a client. Because it's silent on that issue, then it's my understanding, it's my interpretation that you may increase the rent to fair market value. This goes to Prop 33. So let's talk about Prop 33, because in the event of vacancy, if Prop 33 passes, then the whole game will change as far as increasing the rent after a vacancy. So we'll get to that in just a minute. Does this also apply if the landlord intends to sell at the end of the lease and give the 60-day notice to terminate the lease? Does the landlord need to pay the buyout fee? That will depend on the circumstances of the property. But if the landlord is not exempt, then yes, there would be relocation required there. All right, so let's talk about Prop 33 before I get any more questions. We'll save the rest of the questions for the end. Hopefully we'll have some time. So Prop 33 is a Justice for Renters Act. It aims to repeal the Costa-Hawkins Rental Housing Act, which basically Costa-Hawkins was passed in 1995 and restricts the ability of local governments in California to implement rent control on vacant units. So it exempts single-family homes and properties built after 1995 from this kind of rent control. Another way to refer to Costa-Hawkins is that it is a vacancy decontrol statute. So repealing Costa-Hawkins would allow the local governments to implement broader rent control measures. This could stabilize rents for tenants. So, rents would not get to bump up to fair market value every time the premises becomes vacant. There would be a slowdown in how quickly the rents could be increased. This could stabilize the rents, but it could also deter new investment in rental properties in California due to the potential limits on rental income growth. So investors currently need to remain mindful of how they price their vacant units. If you have a unit going onto the market this year, please be cognizant of the fact that if you don't increase that rent to fair market value for the new tenant, you may be stuck for a very long time at below fair market rent. So for renters, the proposition would potentially allow local governments to impose the rent control on a wider range of properties. There's already a lot of rent control in local areas. Single family homes are currently exempt from those rent controls and could become subject to it. New construction would become subject to rent control. For landlords, it would lead to decreased property values and deter new housing investments due to potential limits on rental growth. And the way that rent control is enforced is through local governments, local administrative agencies. So the cost would increase for those local administrative agencies to implement those local the enforcement provisions. So tenant groups back Prop 33, tenants and homeless groups and affordable housing groups back Prop 33, although arguably affordable housing groups are landlords and they could go both ways on this. Organizations like the AIDS Healthcare Foundation argue it would help address a housing affordability crisis. Opposition is led by the California Apartment Association. I believe the California Association of Realtors is against Prop 33 and other real estate industry groups because it would exacerbate, they feel it would exacerbate the housing shortage by discouraging new construction and investment. All right, so just a little bit more on Costa-Hawkins, in case you're not aware of it. As I said before, it does not allow any rent control on a separately alienable unit built after 1995. So that's like a single family residence or condo. And the overriding purpose is to allow landlords to set the initial rent on units that are new construction or that become vacant. There is already in place a civil code statute 1947.15 that I have it printed out here. It states that this section is not operative unless the Costa-Hawkins Rental Housing Act is repealed. So there's already a law in place that takes effect if Prop 33 passes, and particularly this statute provides guidelines for the administrative enforcement of the local ordinances that would be put in place. So what we imagine is that Prop 33 passes, Costa-Hawkins is no longer effective. So all of the cities that currently have rent control statutes will make changes to their rent control statutes to include vacancy controls to limit the amount that rent can be increased when those units become vacant. And so the state of California, Civil Code 1947.15, is written to ensure that owners of residential rental units are not precluded or discouraged from obtaining a fair return on their properties as guaranteed by the United States Constitution and California Constitution. So it encourages the agencies who administer the system of controls on the prices to enact streamlined administrative procedures governing rent adjustment petitions. So I guess we're imagining that if you want to increase the rent beyond whatever the rent control says, you would have to petition your local agency, and they would have to have some sort of streamlined administrative procedure to handle that. And then this law says that it ensures that the cost of professional services reasonably incurred and required by owners of residential rental units shall be treated as legitimate business expenses. And that would include reasonable expenses, fees, and other costs for professional services, including but not limited to legal, accounting, appraisal, bookkeeping, consulting, property management, or architectural services reasonably incurred in the course of successfully pursuing rights in relation to your rental unit. So with this statute, this pre-existing statute tries to do is give some guidelines for how rent controls will happen if Costa-Hawkins is repealed. It also provides for attorney's fees for various parties, depending on what disputes take place. And so what seems to me will happen is that there would be some litigation, there would be some disputes between the landlords, the tenants, and the local agencies about how the rent controls are being enforced and whether they're fair. So that's another byproduct of Costa-Hawkins being repealed, would be some litigation and some legal expense. And this statute provides for awards of reasonable legal fees if you have to go to court or you have to litigate that and you win. All right, so that's, to me, that was really, really interesting. It's interesting to consider how things would change if Costa-Hawkins is repealed. I don't think it's a good thing in my opinion, but my opinion isn't the one that counts. Everybody gets to vote on this, and we'll see. I think that the majority, I've seen statistics that say that the majority of people who live in California are tenants. And so it's likely that many tenants will vote in favor of Prop 33 to repeal Costa-Hawkins. And so that, that is something to keep in mind. That's all I've got. I'll look at some of our other questions. Okay, there was a comment that I was echoing. I'm sorry if my audio isn't good. If Prop 33 passes, when would it go into effect? I believe it would go into effect January 1st. I haven't actually read through the entire thing, so I'm not sure, but usually they go into effect right away. And then it would take some time for the local agencies to update their local ordinances. Another question, if Prop 33 passes, how soon would vacant properties be impacted? If you're in the middle of a costly multi-unit remodel that may not be complete by November, how worried should you be? I think it will, so even if the Prop 33 passes, like I said, it will take some time for the vacancy controls to be put in place. I'm not aware of any areas that already have those vacancy controls on the books. So city councils would have to take action to update local ordinances to create those controls and to create the administrative regulations to enforce those controls. So I think that there would be some time. You'd have until your local city passes their local regulations. Have you heard about the new law that all landlords must accept pets? If so, when does that go into effect? So that law applies to large multifamily property owners that have more than 15 units. So a lot of you can relax and rest assured that it will not affect you, at least not yet. Sometimes when a law is passed, it's just the canary in the coal mine and it shows the trend of where things are going, but that current new law is limited in its effect to only large multifamily property owners. And I believe it goes into effect January 1st, but I'd have to look at that. With inflation down, what rental increase percentage would you agree with? Still 10% over 1 year since last increase. Oh, so just be aware, everybody, the current rent cap in California under the California Tenant Protection Act is 8.6%. As of August 1st, it became 8.6%. Any rent increases for non-exempt rental units, residential rental units in California, may only be increased 8.6% annually. So be aware it's no longer 10%. As inflation goes down, as inflation changes, particularly as it goes down, the cap also decreases. So that's not great. As inflation goes up, then the cap increases up to 10%. But since inflation went down in the last year, the rent cap went down to 8.6. Oh, by the way, that's 8.6 for San Diego County. In LA County, it's different. I think it's 8.9, but you can find this online. I am trying to get through these questions, so I'll keep moving. Would Prop 33 affect properties that are exempt? Yes. Prop 33 has nothing to do with exempt properties or non-exempt properties or California Tenant Protection Act or local tenant protection acts. It's a different area of law. And if Prop 33 passes, then it basically opens the door for a lot of different changes to happen for any property, including single-family residences that are exempt from other tenant protection acts. Yeah, and for clarification, the rent cap is currently a 5% plus 3.6 equals 8.6%. So for San Diego County, it's 8.6%. For other counties, it is different. So it's important to look that up. And if I can find it, I have a nice page that I had created, and I'll if I can find it, I will include that as a freebie too. And it has the county by county rent cap table. All right, I think that's it. Thank you all for coming, and I really appreciate you continuing to come to the webinar.